Good evening and welcome everyone to the Law Foundation's annual Law and You Forum. It's titled this year, Age of Innocence, Revisiting the Age of Criminal Responsibility in Victoria. I'm Lynn Holtain, I'm the Executive Director at the VLF, and it's fantastic to have you all with us. And very many thanks to all our friends who dug deep into their family albums for those images that you saw during that montage of themselves aged around 10. That's what childhood looks like. By its very nature, it's formative. We are growing physically, emotionally, and intellectually. Our community recognises in many ways that pre and early teens are not mature, that different rules should apply at this stage of our development. So, for example, from one of the submissions that was made to the Attorneys General recently on the whole issue of raising the age of criminal responsibility, there was a list of ways in which children are dealt with differently. So, as you're probably well aware, children under 13 can't register for Facebook. Airlines consider kids under 12 unaccompanied minors and treat them very differently on board. The average 10-year-old needs a booster seat to sit safely in a car. In some parts of the country, it's a criminal offence for a parent or a guardian to leave a 12-year-old alone. And yet, in Victoria and across the country, 10-year-old children can be arrested and detained for alleged criminal offences. So we set our standards very differently in criminal justice compared to other aspects of the community. And this raises a number of key questions about how we understand young people and our responsibility to support their development, how we choose to address problems, sometimes difficult and dangerous situations involving very young people. Are kids from the age of 10 to be treated as adults? Or do we recognise a community duty to see them through this massive growth phase and apply different standards? So that's the task for this evening. We're going to lay it out as clearly as we can, what the law is, how it works in practice, and why this is an issue now. Before we begin though, tonight I'm on Bunurong country and our office at the VLF is on Wurundjeri land, both peoples of the Kulin Nation. So I acknowledge the traditional custodians, recognising their abiding connection to the land, waterways and community, and that the lands were never ceded. It's my privilege to pay respect to the elders and to all the generations of the Kulin Nation who have nurtured this land for over 50,000 years and continue to do so. I also welcome elders and community members from other nations who might be with us tonight. We believe that acknowledging the past is an essential step in building a better and more equitable future. We recognise the impact of colonisation, its legacy of injustice, and the marginalisation of Aboriginal and Torres Strait Islander peoples. Victoria Law Foundation aims to break down the barriers to justice for all Victorians through our work in research, education, and grants. We are committed to making a sincere and positive contribution a better justice system for all of us, especially those most in need. Just before I introduce you to our fabulous panel for this evening, just a little bit of format and housekeeping in terms of how this evening will proceed. It's a panel discussion with an outstanding group of people bringing very different perspectives to the questions that we've raised. But as you can see, we are Auslan interpreted, and many thanks to our two interpreters whom you'll see this evening, Therese and Tyson. We're in webinar format, so attendees' cameras are off and your mics are muted. But we will try and make some time at the end for questions. So use the Q&A function and put a short question, or you can thumbs up somebody else's if they're already putting the point of view that you're interested in exploring. But please, for my benefit, keep them brief. It really helps me read the question and get them to the panel in the shape in which you intend. Otherwise, it's very difficult to read and speak at the same time. So, helping us to explore the issues tonight are Liana Buchanan, Leanne Carter, Nick Fancourt, and Melissa Chung. So let me give you a brief intro to all of them. if you're not familiar with them. Liana Buchanan, Principal Commissioner and in the Commission for Children and Young People, and a part-time Commissioner of the Victorian Law Reform Commission. Liana has a background in community legal service and oversight and system reform. She was the Director, Office of Correctional Services Review, and has spent very many years committed to social justice issues, including for people experiencing disadvantage and affected by family and sexual violence. Leanne Carter is the statewide Community Justice Program Lead at the Victorian Aboriginal Legal Service, otherwise known as VALS. A Wurundjeri, my apologies, Leanne, Wiradjuri and Noongar woman, get it right. She has decades of experience in this area, and she manages a range of services for VALS, including the Custody Notification Service, which is critical, the Bagaruk Aboriginal Women's Transitional Housing Program, the Family Violence Client Service Officers Program, and the Community Legal Education Program. And how she's got time to join us tonight is probably beyond us all. Thank you very much indeed for coming. Dr. Nick Fancourt is a paediatrician and clinical lead in adolescent health at Royal Darwin Hospital, and he's an honorary fellow at both the Menzies School of Health Research and the Murdoch Children's Research Institute. Nick provides Royal Darwin Hospital outreach services to remote regions in the NT and to the Dondale Youth Detention Centre, a name you may recall from that infamous Four Corners episode of a few years ago. And Nick spends the rest of his very precious time exploring better models to identify and care for Indigenous children with neurodevelopmental disability. We're particularly pleased, I think, to have Nick's perspective on these issues tonight from a neurodevelopmental point of view. Melissa Chung is the Managing Lawyer Youth Crime at Victoria Legal Aid. And as you can imagine, that means she has very extensive experience in representing children and young people in the Children's Court. Melissa was a lawyer at the North Australian Aboriginal Justice Agency, known in general parlance as NAJA, and also has connections with Dondale, having worked in the defence of 4 Aboriginal young people who suffered human rights abuses there, and then on the Royal Commission into the protection and detention of children in the NT. So thank you all. I am so thrilled that you're able to join us and give us the insights that you all have in terms of this really critical issue. But let's begin at the very beginning and try and set the table, so to speak. So, Liana, what is the law in Victoria in terms of the age of criminal responsibility? I know it sits at 10, but where does it sit in legislation?
So, as you say, the minimum age of criminal responsibility is 10. That's set out in the Children, Youth and Families Act, which is at the moment the statute that covers both child protection matters and criminal matters as they relate to children. So that act says really clearly it is presumed that a child under 10 can't commit an offence. Now, I think you alluded to this in your opening comments. That puts us in Victoria and indeed across Australia as amongst having the lowest minimum ages in the world. There are many, many countries that have ages considerably higher than that.
Melissa, you've also looked, I think, closely at clearly how this sits in law, but are there any other aspects in the legislation that we need to be aware of if we're setting the table on the age of criminal responsibility and the way kids as young as 10 get roped in? Mute.
Fell on the first hurdle. Thanks, Lynn. I'd also just like to say that I'm zooming in from Wurundjeri country of the Kulin Nations, and particularly with reference to the topic that we are discussing today, I pay my respects to elders past and present, and pay my respects to the strength and resilience of Aboriginal children and families. Lynn, there are lots of intersecting bits of the legislation that affect children as young as 10. So bail laws affect children as young as 10. And I know that later we're going to talk about the common law presumption of Dolly inca packs. Children as young as 10 are also affected by child protection legislation, etc. So certainly there are lots of intersecting laws that affect very young children in Victoria.
And as Liana said earlier, you know, this is very low by global standards. The majority of certainly developed countries sit at 14, and we'll get to the discussion around that a wee bit later. But we're under a fair amount of international pressure, aren't we, at the moment, to lift the age. The UN have come out saying 12 at a bare minimum, and please push it to 14 when you can. So there is discussion, there is activity on this front, Liana, isn't there? Got you just as you're having a cup of tea.
There certainly is. And I was remiss before. I too want to acknowledge the traditional owners of the lands on which I'm sitting. I too, like others, like Melissa, I'm on the land of the Wurundjeri people, and I pay my very deep respects to elders past, present and emerging, and to any First Nations people who've joined us. As Melissa said, and as I think we'll talk about, this is an issue that has particular disproportionate relevance for Aboriginal children in this state. So yes, international pressure. So since about 2007, the United Nations Committee on the Rights of the Child has said there should be a higher minimum age than we have at 10. For a long period of time, they pitched that as being at 12. Now, in September 2019, they changed that in a general comment. So they said, no, we've paid attention to the science on brain development. We've paid attention to the evidence. 12 is too young. The minimum age, in fact, should be 14. So indeed, now when Australia comes before various UN processes like the Universal Periodic Review process that we're engaged in as a country this year, what that means is we are sustaining significant criticism from other countries, and we were earlier this year as part of that process. And I think there's no question that will continue. As you say, Lynn, other countries around the world have, some have pitched it at 12, so Scotland, Belgium, many countries, including in Europe, but also South America, other countries have pitched it at 14. Others still have 15 and 16. So we are well and truly out of step.
Which brings us very neatly, Nick, to the evidence that the UN are looking to in terms of understanding the experience of young people and whether or not, 12, 14 is the appropriate age through which to mark criminal responsibility. What is the science in 3 sentences or less, which I'm sure is an insult to your practice, but can you give us a nutshell on the capacity of young people to make decisions of this sort of magnitude at that kind of an age?
Yeah, sure. Thanks, Lynn. And just to acknowledge as well that I'm sitting on Larrakia Nation this afternoon, and to pay my respects to elders past, present and emerging as well, and to all the First Nations people who work with me and provided the leadership in what is a really important topic in the Territory and across Australia. The question around neuroscience has been probably one of the biggest game changers around understanding evidence in this area in recent years. And the science is relatively straightforward, and it's telling us that adolescence in itself is another developmental period, just as being a small infant compared to a young school attendee compared to an older child. Each has their own developmental phase, and that adolescence is no different. We see it physically in puberty development and growth. The same is true for brain development. And there are 2 components to that. One is that even just by imaging brains of a 10-year-old versus a 25-year-old, we know there's development in some of the higher order abilities that we develop around impulse control, emotional regulation, reasoning, connecting actions to consequences with a large time lag. But we also know there's a lot of variation for children of different, for children of the same chronological age. And we'll talk probably a little bit later about how that intersects then with disability and health needs. But it shows us that there's also strong chronological cutoffs, and not always as easy as they might seem.
So what about, and I know we'll go into this in more detail later, but the kids that do end up in the criminal justice system, we know a fair bit about that group, don't we, in terms of their developmental issues and challenges. What can we say in general terms?
So in general terms, these are usually a group of kids who've come into the system with high needs, high background needs of welfare needs and disability needs. They're kids who are more likely to have mental health needs, alcohol and drug use issues, severe neurodevelopmental disabilities. And in one lens, that group has been captured by justice, and justice is dealing with them in its process. In any other circumstance, those kids could have been picked up in a different process, education, health, housing, and be dealt with in an entirely different view. It's just that for whatever reason, this particular group that come through justice are dealt with in that particular framework and lens. And we miss sometimes the opportunity of seeing the broader picture, I think, of the risk factors with which these kids come into care.
As you say, we'll dive into that in a bit more detail in a moment or two, but thank you for that. That's extremely helpful. I think we're getting a picture now of, you know, what our law is and the position that young people are at in terms of their development at this phase, which, as you say, is you know, still at a stage of significant growth and development. Before we proceed to talk about, you know, the impact of this lens, as you put it so neatly, Nick, I want to have a look at what the current situation is in Victoria. So, Melissa, do you know how many kids under 14 years are in fact involved in the system, or Liana?
I think the Sentencing Advisory Council reported last that it was approximately about 438 young people who were dealt with by the Children's Court in that cohort. And I think, and Leanna, you may have better data than this, approximately about 29 were in detention in the last year.
That sounds about right. I mean, I'll say a couple of things. I've been in my role for 5.5 years, and when we look at the data, because we get data from youth justice, because we oversight youth justice, on average, in any given month in that 5.5 years, there have been at least one child, 13 or under, usually two, sometimes more, in youth justice custody. So that's kind of, you know, you think about a 10-year-old, an 11-year-old, a 12-year-old that you know, and think about them in custody. And hopefully we'll come back to talking about what our youth justice facilities look and feel like a bit later. There are about, I think, 69 young people, children, 10 to 13, on any average year in the last kind of 10 years who are subject to community supervision orders. I don't want to steal some of the thunder or some of the kind of very, very serious issues I know Leanne's going to cover, but 30% of those are Aboriginal children. Similar disproportion applies when you look at the number of children brought into custody. We have massive overrepresentation of Aboriginal kids in the youth justice system to begin with, but that is particularly disproportionate. It is even more so by a considerable amount when we look at children who are 10 to 13. The other bit of data that I'll share now, there's lots more, in terms of which children come in and why, is that when we look across the last 10 years, 98% of children who are coming in on remand. So the reality is, by the time most of these children are actually brought before a court and receive a sentence, if they receive a sentence at all, then the court makes a decision, custody is not the appropriate place for them. So that's, I think, worth us thinking about.
So they've been in custody on remand, and then when sentence is passed, if it is, custody is deemed inappropriate to their circumstance.
Absolutely, and some are bailed long before they are brought before court for hearing. So there's a whole lot of questions about our bail system, and it intersects a bit with Dolly that we'll talk about. But that is the reality. The reality is that the vast majority of 10 to 13-year-olds who end up in custody, when they come before a court properly, the court decides they don't belong there.
Leanne, tell us about that gross overrepresentation that Liana has described in terms of Aboriginal kids in the criminal justice system in Victoria. What sits behind that? Give us, your nutshell answer on that really massive question.
Oh, my nutshell answer. I suppose, one of the difficulties we do have is around the lack of timely data as well. Sometimes we're sort of behind the eight ball. We're catching up on what the reality of the situation is, unfortunately, because of, the information available. But I think, Liana did hit it on the head, is that we are so massively overrepresented, particularly with our young people and our children within those age groups. And given that we make up 3.3% of the population, as we know, I know in 1 year we had over 600 children, that were locked up across age between 10 and 13. And we know, as of June 2020, there were 10.9 Aboriginal children under 18 in detention on an average night within Victoria. And when we break that down, that actually equates to, an incarceration rate of 10.7, and that's when we get down to the specifics of it, it's an enormous amount of numbers, and when we look at what actually sits behind it, which is the reason why we're saying the age should be raised, is we're talking about the findings of what the Royal Commission into Aboriginal Deaths in Custody found. We're talking about government policies. We're talking about dispossession. We're talking about poverty. We're talking about poor health outcomes. We're talking about a lack of housing. These are absolutely fundamental to anybody's life, but particularly the lives of young people and children as they're developing and as they're, going through that really stage of being nurtured and cared for and growing. And, and as Nick said, we got kids at very different stages. And, we know brains don't develop until around the age of 25, which is why we see this risk-taking sort of behaviour amongst young people. But when we're talking about these young people, we need to unpack who these young people are, right? What is actually going on behind these young people? When we're talking about the incarceration rates, particularly of young Aboriginal kids, we're talking about a lack of diversion. We're talking about a lack of cautioning by police. If you live in a regional area, police are more likely to know your family. They're more likely to know all your relatives. You can't just go down the street anonymously without perhaps being pulled over a few times. And they're the sort of stories that we hear from young people. And, when we break down what's actually going on, we know that education's a key factor, for example, an absolute key factor to keep kids engaged and, to keep them on track. Now, over half of all the young people previously in custody had been suspended or expelled from school. So there goes one major protective factor within that young person's life. And then, we look a bit further and then we see, young kids, or young adults, or they may present with a disability. And that's a big issue, particularly with Aboriginal and Torres Strait Islander people, both within the adult system as well as within the youth system. And one of the last studies actually showed that 11% of Aboriginal people who were in custody were registered with disability services.
Mm. I'm going to come, Leanne, to that incredible matrix of systems and lenses that Nick described earlier, and the way we see kids and which system they end up coming through, and therefore, what that means for their development and for their futures. But Melissa, before we get into the sort of tricky area of what is known in the common law as Dolly inca packs, which is a very odd name for a very weird concept, let's talk briefly about the sorts of charges that are laid against kids aged sort of 10 to 14. What are they there for?
Overwhelmingly, we see what we class as property and deception offences laid on children in this cohort. And this is behaviour that ranges from stealing food from a supermarket, a sandwich from Subway, lighting, leaves in a park, or going to abandoned buildings. It's really opportunistic offending, low-level offending. And actually, there's not that much offending that relates to what we would class as violent offending or offending against the person. So it's really childlike misbehaviour that we see. And I know that we'll talk a little bit about the overrepresentation of children who are in out-of-home care. So many offences relate to misbehaving at home. So we have seen children charged with assault when they've squeezed a bottle of mayo at a worker and it's got on their hair, or we've seen, you know, breaking a glass and being charged with property damage in that respect. But I think overwhelmingly what we need to understand is that these children aren't committing really serious offences. You know, at times they are being remanded for really low-level offending, like stealing 4 cans of Coke or a $2 box of matches. And as Nick said, there is got to be a different way of dealing with this kind of behaviour.
And we'll get to the sort of counter view, if you like, of that in a moment or two. But Liana, can you give us an easily accessible definition of Dolly incapax, which is a phrase that I must admit I am now, you know, much more familiar with than I was a couple of months ago. It's basically the presumption of innocence, but it comes at a price.
That's right. So essentially, and it is meant to apply in Australia, it is a rebuttable presumption that children between 10 and 14, so 10 to 13-year-olds, are not able to form the necessary intention required to establish a crime. So if you look at that, on one view, the law recognises that children between 10 and 13 should not be the subject of the criminal law and the criminal justice system. In practice, it doesn't work. Melissa might be able to speak to this, or others, but the research about how Dolly applies in Victoria is really very clear that it actually doesn't operate as a rebuttable presumption. In practice, charges are laid, the police lay charges, and it's a matter for the defence to raise Dolly. Or to raise that the child doesn't have capacity, then it's a matter for the defence to prove that, to get the psychological evidence to prove that the child lacks the requisite capacity. And of course, that doesn't happen immediately. So what we see often is significant delay, and sometimes during that delay, we have the child on remand, in custody, just so that the system can turn its mind to whether indeed that child should have been charged in the first place. I'll just share one example from the last couple of months. A young girl, 12 years old, long history of child protection, out-of-home care, long history of trauma. Minor offence. Came before a bail justice, was remanded into custody, I think in the early hours of a Saturday morning. When her matter was finally resolved, in the end, because of particular intervention, she got bail. But when that matter was finally resolved, indeed, she was found not to have the capacity. When that rebuttable presumption could be tested, she shouldn't have even been subject to charges at all. That's not a system that's going to work for these kids, and it's not working for them.
So it seems to turn the onus back, Melissa, on the child and their representatives to prove that they don't have capacity, even though initially it's intended as a presumption of innocence. So it seems to be, as Liana has pointed out, a very convoluted legal process which draws kids into the system in order to resolve that they shouldn't be there.
That's right. And we often see that children who have the presumption of Dolly that should apply to them fall into the quicksand of the criminal justice system, like Liana was describing, in the period between when charges are laid and when a Dolly finding is or isn't made. And we certainly see that that's the high risk period for these very young children to come into custody, to go into Parkville, and to have very traumatic experiences of custody that are harmful. And often, and I'm sure we'll get to this later, people who say that the age shouldn't be raised say that these young people need the justice system to get the help that they really need. And I would say in response to that, that actually the systems and processes that the criminal justice system impose are harmful in and of themselves, and don't give the kids the help that they need, and that help can be obtained in other ways. And I'm sure Nick will be able to talk to us about that in more detail.
Well, nicely done, Melissa, because I'd love to hear Nick on this in terms of, the anecdotal sense would be that systems like this are not going to produce a positive outcome for young people. But what do we know from a paediatric point of view about the impact of detention on young people and what that means for their education, for their development, for their prospects? It must be a disruptor, but what's the evidence?
Yeah, it's a really good point, and I think again, of the children who are entering the justice system, and particularly those who are entering detention, we're already starting with a cohort of kids who have been left behind on several different fronts. I'm a paediatrician. I take this and I view this very much as a developmental issue. Again, and the disruption that you see for taking kids out of family and community, for instance, taking kids away from structured education, imposing on kids a disruption in the development and transition between in adolescence, where we're trying to move slightly away from family and engage more with peer groups, but that peer group is all of a sudden more of a deviant contagion kind of peer group, because everyone's in a detention facility rather than the therapeutic rehabilitative kind of model. We know all those things impact development, impact behaviour. And how do we know that? Well, partly because we know that recidivism is so high in those who go through detention compared to those who go through other models. We also know that of those kids who go into detention, their chance of self-harm, depression and suicide is significantly higher than kids in the justice system who don't go through that model of restorative justice, and certainly higher than kids who don't go through the justice system at all. Yeah,
it's pretty compelling. You alluded earlier, Liana, to the intersection, and I think Leanne did too, of systems and the impact of out-of-home care. And the Sentencing Advisory Council did a very powerful piece of work on what they call crossover kids. Can you just describe what crossover kids are and why they are relevant in this context?
Yeah, absolutely. Crossover kids are children who have involvement with the child protection system and potentially the out-of-home care system. So they've been removed from their family and taken into the care of the state because they've been subject to a level of risk or harm, or the state has and courts have considered them to be such. And they're also, this is the crossover bit, and they're also involved in the youth justice system. So you're right, the Sentencing Advisory Council, and I for one am really grateful to some of the work they've done in this area. They looked at this really closely, and they found, as you might on one view imagine, significant overlap, but particularly significant overlap amongst those 10 to 13-year-olds, or those children, young children, who are young, 10 to 13, when they first come before the children's court. So of those, they looked closely, of all of the children 10 to 13 who came before the children's court in a particular time frame, a half had been involved with child protection, a third were actually children who'd been removed and were out of home care, and a fifth, more than a fifth in fact, were in residential care. Now I'm going to stop and just pause there, because think about that. 1 in 5 10 to 13-year-olds who get in contact with the criminal justice system are in residential care, and there are only about 450 kids in resi at any given time. So that is telling you something about not only the experiences these children have had on their way into the care system, but also what that care system is and isn't doing for those children to keep them safe and support them and kind of help them to recover from what they've been through.
Leanne, we keep coming back to Nick's articulation at the beginning that, this is a lens that some kids are caught up through or in, and there are very different ways of dealing with young people depending on whether or not, they are identified through a health or an education or a different system. But can you paint us a picture of those crossover kids in your experience, and what is the kind of knot of issues that they both come to criminal justice with, and that adds to? Is that clear?
Reasonably. Look, I think when we're talking about crossover kids and kids in out-of-home care as well, Aboriginal children and youth are 15 times more likely to be placed in out-of-home care. And, you know, so those numbers themselves are pretty high. And we deal with a lot of what we call, you know, resi kids, or kids that are in residential care and out-of-home care on a daily basis. And this, you know, when we're talking about low-level offending and things like that, you know, we had a situation where a young person had got really quite upset. They had a disability. They tossed something onto the floor which broke, and then, you know, all of a sudden you've got these workers going into this panic and going through this process and contacting the police. Now, by the time the police arrived, the situation had de-escalated. Everyone was nice and calm, but the fact that the police had attended then escalated the situation. But what happened with this young person in particular was, by the time they were taken into custody, they were taken to the station and they were looking at a remand application. But that young person was not charged with any of the offences in relation to what took place at the resi unit, but rather their interactions with police. And, you know, when we're talking about these young people and when we're dealing with these young people, you got to think these are kids that have been taken away from their communities, their families, that, you know, there's a loss of culture and connection a lot of time, and they're dealing with significant trauma, if not, you know, people coming in with sexual abuse and, you know, really horrific circumstances. And then, as Nick said, when you take that young person and you place them in a prison system, right, which is potentially subjected to strict searches and isolation and, you know, all these other procedures, you are re-traumatizing that young person. And, you know, it is not rocket science to sort of see that, you know, the potential risks of what they're dealing with are going to be heightened. The mental health, the suicidal ideations, the self-harming, you know, all of those things. And on any given day, any young person that we deal with can come with every ticker box, so to speak. They may be removed. They may have a disability. They may have some medical issues. They may have some mental health. They might have some substance issues just thrown in. You know what I mean? So the complexity of those situations need to be taken into account on an individual basis, and without taking away the intersectionality of who they are. They are a young Aboriginal person. So in order to understand them, you need to understand them as a young child, Aboriginal child, or a young Aboriginal, you know, person, as I said. And that intersectionality is absolutely crucial to setting those preventative and those early, you know, interventions we'll talk about later as well.
Liana, just to put the counter position, police say young people aren't in jails in Victoria. They're just not. That there are layers and layers, and this is a quote, of diversionary programs and options, and that the numbers are so tiny in terms of any kind of custodial issue that this is not a problem, and that we do not need to raise the age, and that they want to have the options to take tougher lines with young people if the need so requires. How do you respond to that? Because that's a view that many people might share.
So let's start. The numbers are, you know, it is important to be balanced on this. Victoria does do relatively well at diversion. We have relatively low youth custody rates compared to other parts of the country. So yes, we do have some good options for diversion. We do have some good options for cautioning, for formal diversion. That we do have some layers, and they're layers that are gradually being improved. We've already talked about some of the potential systemic racism that applies in terms of cautioning decisions, for example, and diversion programs, but you know, they're not perfect and they need to be improved. Notwithstanding that, what we see is that on average over the past 10 years, there have been 108 remand orders every year for 10 to 13-year-olds, bringing them into Parkville. On top of that, there have in that 10-year period been 21 sentencing orders in respect of 10 to 13. So we're not talking about no children. We're talking about still significant numbers. And you think about what is happening to those young children. We haven't talked about this, but those of you who have not been to Parkville, you might have in mind some kind of home-based, residential, therapeutic environment that's really kind of conducive to children's rehabilitation. One of the jobs that I used to have was to investigate and oversight adult prisons. So I've been to every prison in the state, every adult prison in the state. Parkville, in terms of the physical infrastructure, the barb, the razor wire, in terms of lack of movement control, in terms of the look and feel, the austere environment, it looks more austere, more intimidating than any of the maximum security prisons that we have in Victoria. It is in no way reminiscent of a place that is therapeutic and good or appropriate for children. Again, I just ask people, think about 10, 11, 12, 13-year-olds in your own lives. That is not a place for them, not to mention all of the issues that continue, although they're improving in terms of the management of youth justice. Leanne mentioned a few of them: overuse of isolations, use of excessive force. Again, we've done 5 years of work exposing some of that. It's not right for children. In terms of police wanting to be able to do something, yeah, of course, the community will want something to be available. My very strong view is there's no good in just being able to do something when that something doesn't help. It doesn't help the child. It doesn't help community safety. It doesn't address the issues in any way, shape or form. Arguably, in most cases, it compounds them. So if police and indeed the broader community want options for dealing with, responding to children with pretty complex needs and challenging behaviours, then we need to look at something quite different, because the criminal justice response just doesn't cut it.
Nick, I think your position would be very current with that, in terms of the fact that this doesn't actually result in a good outcome in any respect, medically or developmentally for young people. It doesn't fix the problem that society is allegedly addressing.
Yeah, I think that's right. And I think probably it's a reasonable time to pause and again sort of reflect on some of the numbers about who is the common young person who's coming into detention, particularly those who are sitting on remand for some time. And we know that at least 80% will have one mental health issue, at least 60% will have two significant mental health issues, a lot of drug and alcohol use. There's been a lot of attention put across the country towards fetal alcohol spectrum disorder recently as one concept of a neurodevelopmental disability that is strongly associated with children in the youth justice system. And probably the best work in Australia recently has been a study from Western Australia looking at kids at Banksia Hill Detention Centre. And of 99 kids, 36 of them met criteria for fetal alcohol spectrum disorder. And just to give you a sense, to meet criteria for that, it's a very strict diagnosis. You have to have a severe, profound disability in at least 3 different neurodevelopmental domains. If you look at kids who just had one severe, profound disability in one domain, that was almost 90% of those children. So that's the kind of cohort that we're dealing with. And what we would say is to be therapeutic and to understand both why these behaviours are happening. As Melissa says, in these young kids, they're often not severe behaviours to start with, but we're dealing with neurodevelopmental disability, we're dealing with impulse control, trauma, and to be able to package a therapeutic model that reduces recidivism is really important in those kids. So we can't do that in a detention centre for all the reasons we've discussed. But the flip side to all of that is these things I don't think run against either victims' rights and the ability to have victims involved in a restorative process, and they don't run against public safety either. At the end of the day, all of these children are going to be out at some point. We don't lock anyone up forever. we have an opportunity in responding to the disability, in responding to the health needs, and in responding to the behaviour to make sure it doesn't happen again. That is the ultimate goal that we all share in the public safety model.
Yeah, and we've got this tension then between an old system that is punitive, that is intended, I think, to apply, probably very out of date thinking to a contemporary problem. What can we do from here? What does work? What have you seen in your experience that does make a difference? And I recognise that tailoring responses very carefully to each individual is going to be critical. But is there a systemic response that you think we can take at this point?
Well, I think we're talking about one of them. I think raising the age is a foundation issue. I think, as Liana alluded to earlier, for all of the distress that we feel around seeing kids in detention, there's also a lot of success stories in diversion and in diversion programs across the country. What we don't do well at the moment, and I think Leanne was reflecting on this, is collect data, properly analyse and monitor those programs, and learn from each other as we do them. We don't also look too far abroad to know that there are some really successful programs in New Zealand and Spain and elsewhere that have helped drop numbers coming into the court process and drop numbers of recidivism. So yes, there has to be that flexibility, as you say, and ability for the system, and the system I mean is abroad, not just justice, but the entire community system, to be flexible, to understand the individual child, to be able to construct the need, respond to the needs and construct interventions for that particular scenario. But there's also components around good diversion, raising the age, these kind of, I don't want to say simple things, but they're the things you can easily put on the table.
Leanne, what's your perspective in terms of trying to join up the response? Because that seems to me to be one of the issues here, is that we've got, as you and Liana and Melissa have all alluded, a number of different responses that could pick up these kids, and they end up in the wrong channel.
Absolutely. And prison's no place for children. Prisons are inherently violent, and they're not geared to be, as Nick's saying, there's some programs that are therapeutic, but that's not the purpose. The purpose is generally, for that, rehabilitation, diverting young people. But there's also studies that show none of that works. Sending young people to prison is not working. So we need to change our way of thinking. We need to change the way that we're looking at young people. We need to change the way that we're thinking about how we're going to manage that young person, because to get to a stage where we're sending young people to prison because that's the only way that their behaviours can be managed or the issues can be addressed, that's a really sad state of affairs, because that says to us that whilst we've got these programs in community, we're not using them. We're not using them to the benefit. We're not using them early enough. There's justice reinvestment programs, there's intervention, early intervention programs, and we should be targeting the kids that we do know are coming through, that are coming across the radars, that are coming across, missed half a dozen days at school, within a few week period. Hello, that's a trigger. That's a red flag. Something's going on there. So each of the organizations that engage with that young person, their carers and their family, need to sort of intervene at that time. But the families and the services that support them also need to be properly resourced, because, if you've got a family who's struggling, and there's no resourcing or there's no programs around, then we need to target that, and we need to ensure that they are there, because as we know, prisons aren't working, and they're not getting the outcome. And the way I think about this is the same way I made mention last week, was that we've currently changed the public drunkenness. We're in the process of changing the public drunkenness laws. Now, that was previously dealt with, or, you know, is going to change from a very justice response to a health response. So why can't we do the same within this space? Why can't we take away the justice response and provide a health response, you know, to these young people, you know, that we're seeing? And when we're seeing these kids, they're not, you know, they're kids that aren't just in out of home care, maybe spraying some silly spray on a thing and get picked up with a group of kids, or, you know, all these lower level offending, but they come with so many issues. And unless we're addressing the root causes and the systemic issues that are sitting below their offending, whether it be from a disability or something else, we need to separate out that behavior to who that young person is. And then we can actually start to address what the fundamental issues are going on, or we're going to continue to have, you know, incarceration rates being exceptionally high. And we're going to, you know, continue to have these young people falling through the gaps.
Melissa, you made a really interesting comment to me when we first caught up and had a chat, that you know, the age has changed in the past. In fact, the age of criminal responsibility in Australia used to be 8, and it got raised to 10, and the earth didn't stop and the sky didn't fall in. So how is it that we have 10?
That's right. Well, we have 10 when Parliament in 1989 passed the Children and Young Persons Act from memory. And that was the result of the Carney report, which made a whole suite of recommendations that were relevant to the Children's Court. And government at the time saw fit to change the age of criminal responsibility from 8 to 10. And I think what all the panelists are saying is that we do have the services that are available to help these young children. Their health services, child protection services, welfare services, education. And I think that having a child present in the criminal justice system is an illustration that those services have failed that young person. And we should use that as an opportunity to explore what's going on, as Leanne was saying, what is going on for that young person and what is causing that young person to misbehave, to engage in harmful behaviours, and using that as an opportunity to really explore how the service system as a whole, how the community as a whole can assist that young person and their family if they need it.
So to circle back to my comments at the very beginning, Liana, we have this tension about who bears the responsibility for this behaviour. Do we say kids at the age of 10 are responsible for criminal acts, or do we accept that they are in a very different phase of life, and that, as Melissa has just put it so well, there are a whole lot of other issues going on and other systems which their poor behaviour may reveal to us that it's our failure, not theirs? Is that the tension?
That indeed is the tension. And so you're absolutely right. We are currently holding the child to account for factors that partly are outside their control because they're still a child and have not sufficiently developed to control their behaviour, their thoughts, their capacity for consequential thinking in the way that adults have. But also we're holding them to account often for the fact that they are indeed, their behaviour indeed, is the manifestation of systems that have failed them. In child protection, I see so many situations where children are the subject of report after report after report to child protection, and nothing happens to change things for those children. Now, don't get me wrong, I'm not advocating for more kids to be removed and taken into care, but what that shows is that we don't even with, for example, that cohort of children who are in families struggling, who have a raft of issues going on at home, and there are risks to those kids. We don't have a service system that then steps in and wraps around that child and their family and makes sure those supports are there. What we see again and again and again is as those young children grow up, again, they continue to be the subject of multiple reports with nothing happening. By the end of primary school, often they start to kind of play up and act out in school. By early high school, they've disengaged, and for many of them, they're starting to get in trouble with police. You know, holding the individual child to account for that is not only counterproductive, not helpful, it's profoundly unfair. So I do think there's a tension, and I think we have to pass through it. I think we have to put some very outdated assumptions and conceptions aside.
Leanne, child protection has a bad name in many quarters, and it's, I think, a system which is under enormous strain. I don't know if you saw it, but there's a series that's just started on SBS about looking at child protection services in New South Wales. And what you see is a whole bunch of people who are really trying to do their best for families and young people. But the reputation of that system is that it can be punitive, it can be inappropriate, it's culturally not servicing communities well. So when we say wraparound services, do they need to change as well? I mean, does child protection and education and health, do they all need major surgery also in order to achieve the outcome that you'd be looking for?
If they're going to engage with the young person, absolutely. Because if the young person needs to be the center, it needs to be strength-based on that young person, that's the focus. But then if we move past that, you got the families, you got the carers. And quite often what happens is a lot of the kids that get removed, it's because mum and dad might have, they might be with a violent partner, right? There might be mental health issues or substance issues that place that child at risk, right? But what we need to do is we need to actually go back and revisit. How can we help mum and dad? How can we help that family? What resources can we actually put in at the very front end, at that very pointy stage when things start happening, not when things start tumbling and, they're on their third or their fourth notification for that child or something like that. But I think, if we're going to look at it, everything needs to be done, in our perspective through that cultural lens, particularly when you're dealing with, ensuring that young person keeps contact with their family and their connection. And if not their family, definitely, keeping that culture and that connection going, which is really, really key and fundamental to, that young person's identity and who they are. And, and as we know, your identity gives you a sense of belonging. So without that, you're a lot more lost. But when we're talking about holistic wraparound, we don't want to stick a young person in a room with 20 workers or something like that. But, surely there's a better way of networking to ensure that the needs and the issues are addressed as well. And to each department in each area being held accountable and, and reporting what is actually going on, because a lot of time it's a lack of communication, it's a lack of consultation, and that's where services drop off and, they give up on a young person. And the next thing you know, they're in a too hard a basket or they don't know where they are.
We've got a great, it's put as a question, but I think it's actually a terrific comment from Sadhna, who says, what is our objective? Creating a rehabilitated, engaged, productive member of society for the next 60 or 70 years, or creating a recidivist for the next 60 or 70 years? How do we shift funding and, are we aligning our treatment of these kids with our long-term objectives? And I think that's exactly tension that we've just been discussing, that we're imposing a system which doesn't in no way deliver the outcome that we allegedly are looking for. Melissa, is raising the age the first best thing to do right now, given all of that challenge?
I would say yes, but it's not the only thing. And I would say that urgent bail reform is the complementary piece to raising the age, as that is also a really difficult and problematic framework for children to work within.
I've got a question for you that's come in from Simon. Do lawyers representing children under 14 refer to principles of international law in your argument to judges around sentencing, and have there been any precedents applied in that respect?
You certainly can refer to international covenants and precedents in your submissions. I think what's important to remember, though, is that the judicial officer has to apply the Victorian law as it is. And for us, that's the Children, Youth and Families Act and other associated criminal statutes. And it certainly provides context and detail to your submissions. But I think what we've all seen over a long period of time is that the Victorian law has not kept up to step with contemporary research and understanding of developmental science in children.
Leanna, to you, is raising the age something we can do, relatively? I don't know how easily it would be done. It seems that Section 344 of the Act wouldn't be too hard of a shift to make, but you would tell me otherwise, perhaps. But is that a critical step to take?
Yes, absolutely. For all the reasons that we've been discussing, it's a no-brainer, and it is, from a legal point of view, it's very straightforward. My very own 12-year-old is in front of the window trying to make me laugh, just so we're all clear, just in case you think that, the children in my family behave well all the time. So legally very easy. Politically, is another question that I won't speak to. In addition to, now my dog's making a loud noise just to kind of add to the party. But in addition to the legislative change, I want to let people know, I think somebody has asked a question about this. The ACT is actually really worth watching right now, because the ACT government has committed to raise the age. But they said when they did that, okay, but we're going to think through what else we need to have in place before we do that. Cautious, but probably a sensible approach, so that, everyone's thinking through, well, what do these children need to have around them? And just yesterday, as it happens, the report was made public and it's an independent report commissioned by government, but ANU and another organisation have worked on it, and it talks about what needs to be in place, what needs to be set up to improve services. So it talks about we need more trauma informed, we need more safe accommodation for children, because that's often a reason that they end up in custody. We need more integration, as Leanne was talking about, services working together, and they have recommended that a multidisciplinary therapeutic panel be established. So children who really need additional help are referred to this panel, their needs are assessed, and then the agencies involved work together to make sure those children's needs are met. That seems incredibly sensible to me. Now, I don't think, we can talk about whether that's the precise form that we need, whether it needs to be legislated, etc. But just having an eye to what else needs to be strengthened. There are, as Melissa says, lots of services already, but what might need to be strengthened to make sure that we're giving these kids the support they need, as well as raising the age. But all the issues that we've talked about, all of the situations that I see in terms of young children who've had pretty horrendous lives ending up in Parkville, it's pretty outrageous. And I think as a society, we should be calling for better.
Leanne mentioned earlier the shift around public drunkenness. Leanna, does that give you hope that there is at least a sensibility around a health perspective in some of these issues rather than a straight criminal justice one?
It does, and it absolutely does. And I would say the government that is prepared to make that shift in the law to reflect the science, the evidence, good understanding and good public policy should also be the same government that can make this shift to recognise that the response that these kids need is not a criminal response, it's a welfare response. And we need to put that in place, and we need to change the legislation as a part of that.
Leanne, in your list of priorities, is raising the age top of it?
Absolutely. The government, when they release a Closing the Gap, are talking about reducing incarceration rates for young people by 2031 or something, and by 30%. And studies have shown that if raising the age is put in place, that'll reduce that to, between 14 and 15% straight up of the number of kids that are going into custody at the moment. And this has been one of our driving priorities, is to, ensure that these particular changes are made, because we don't want another generation of these young people then going into adult prison. And, and then continuing with the deaths in custody and the situations that we've got within the adult prisons and things like that, and when we've got an opportunity here, we need to monopolize on it, and we need to jump onto it, and we need to, really, really sort of stand up and be brave. And I think that's what's been most disappointing through this, but most not so disappointing, if that makes any sense. So I think what's really disappointing is the lack of response from the government, the fact that they had over 30 countries saying, hey guys, what are you doing? You really need to, look at this. And they're sort of like, well, that's not our issue. It's a state and territory issue. We're not going to deal with this. And that's really disappointing, because the numbers and all the studies have showed so far that a majority of community people support this. The community support this. So it's time the government actually really turn their, as I say to my own kids, have you got your listening ears on? They need to turn on their listening ears and ensure they're hearing. They need to take them steps. They need to be brave, and they need to make the changes. This is what we're asking for. So yes, it is a priority. It's a short answer.
Nick, just finally on the whole age question, is 14 about right? I mean, as you've said, there is enormous diversity amongst 14-year-olds or 10-year-olds or 12-year-olds as to their capacity. And we've explored already, the issues around disability and trauma and FASD and other issues that kids come into criminal justice with. Is 14, I suppose it's better than 10?
Yeah, I think it's another tension, isn't it, that we have to discuss around, if we're talking about listening ears, and we're all far more used than we used to be around the idea of health advice informing public policy, but the health advice would be there's a lot of variation, and the disability creates a lot more variation than there normally is. I've got 15, 16-year-old kids in my care who function at a primary school level, but they're in detention because of their chronological age, not because of how they perform on an IQ test or a speech and language assessment, for instance. So there is a bit of a tension there. I think, the reality around consent in its broader sense is always leading us back to a need to have a line in the sand somewhere. There is an ability in public policy and law to have some flexibility around that, and to acknowledge that sometimes individual circumstances need to be accommodated for. And I think that would be a reasonable way to create some balance.
Another whole discussion in that, I think, as so many of these issues are just literally sort of the lightest tug on the thread of massive areas of great interest around public policy and the way in which we understand our community and our society, and what we want it to look like, and how we treat, as Hubert Humphrey put it, the most vulnerable, and what it says about the kind of society we are. And in fact, I had a quick look back at the original quote, which is often used as an aphorism around, the kind of society that we are. And he starts that by talking about children. So I think he hit the nail on the head when he said that it says a great deal about us as to how we treat the most vulnerable in our midst, indicating what kind of society we are. It starts by talking about how we treat those in the dawn of life, our young people. So with enormous thanks to all of you, I think we need to wrap it there so dogs can be fed and children can laugh and people can go get dinner. But it's been a really intriguing and I think extremely thought-provoking conversation. So thank you enormously to Liana Buchanan, Nick Fancourt, Melissa Chung and Leanne Carter for being with us tonight. It's been a terrific, I think, really valuable insight into these issues, which, as we've discussed, are currently on the table in the ACT, with legislation apparently on the books or to be drafted for next year. And as we understand it, there's an intent to discuss this at the meetings or the meeting of attorneys general from across the states and territories very soon. So we await further developments on that. We did invite the Victorian Attorney General, Jacqueline Symes, to join us this evening and to share her insights into this issue, but she was unavailable. My final thanks, though, to the great team at the VLF for making tonight possible, to Helen Papadimitriou, to Lisa Pryles, Jackie Matthews, Matthew Hurst, Anisha Sarab, and Sam Goodyear, who have all made this as positive an experience, a viewing experience, as we possibly could. So thank you again for being with us. Come back again for next year's Law and You Forum, and go well.